I'd like to welcome our guests for this hour, litigation trial attorney Rich Schoenstein and former federal prosecutor Neama Rahmani. Rich, Neama, I mean, these kinds of allegations are fairly unheard of because the clerk of court has a job to do and they should not be speaking to the jury. They should not be having such conversations. These are only allegations. What's your initial reaction, Rich?
Well, these are shocking. This is much more than I was prepared to receive today from Murdaugh's defense. We knew they had something, but I didn't imagine anything like this. And I will say this, Dick Harpootlian and Jim Griffin had better be right about it because they are putting their reputations on the line. They're not just making an argument in a case about what the facts and the evidence show. They are accusing a clerk of the court of specific jury tampering and related misconduct. And that kind of allegation, if you're an officer of the court, you better be right about that if you're going to make that allegation.
Yeah, great points. Neama, weigh in. What are your thoughts?
Well, I agree with Rich, but if you take what they're saying at face value, that they have an affidavit, they have three from one juror, one dismissed juror, and one third person, that's pretty strong evidence. Obviously, we don't know if this is true. You know, defense lawyers make all sorts of allegations on appeal, but this strikes me as very strong and a good basis to get a new trial. If I'm the prosecution here, what I do is think about trying Murdaugh for the fraud cases first, just in case. You have a little bit of a belt and suspenders approach. He's admitted to committing all sorts of fraud, probably enough to put him in prison for the rest of his life. Obviously, you do want to get those murder convictions as well. I mean, you know, there are individuals who have lost their lives, but that's something I would be thinking about really spending a lot of time on those fraud cases right now from the prosecution.
Oh, great strategy. I like your idea of starting with that fraud piece first. And I want to take a look at some of the specifics because, again, they filed the motion and we have a copy of that. I printed it out. And yes, I may have killed too many trees, but I get in the weeds with these things. A couple of the quotes I wanted to share with you first. As the defense began its case, Ms. Hill told jurors, y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you. Let's bring you one other gentleman, and that is, additionally, Ms. Hill and juror number 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Now, of course, these are still just allegations, but talking about those allegations, Rich, even the allegation that they're in the restroom privately, even if they're talking about something completely unrelated to this case, that in and of itself, in my experience as a former judge, is unusual. You just don't cross that line. You try to keep it separate, in my opinion.
The standard we always apply to these events, Judge, is the appearance of impropriety. You don't want the judge or anyone on the judge's staff doing anything that would appear to be prejudicial, even if it's not prejudicial. So maybe those conversations happened and they were perfectly innocent. Maybe the juror had a personal matter that they needed to discuss with the clerk. That would be a legitimate reason to have the conversation. But even so, if they were of that duration and frequency, it's very troubling, just that fact alone.
It is very troubling. And add to that, Neama, and I'm hopeful we can pull it up. I'm looking for it right now. But during the actual trial, Judge Newman actually made a comment about being bothered that the clerk chose to interrogate a juror instead of just bringing it to the court's attention. And so, in and of itself, is that a problem?
Oh, it is a problem because if there's ever questioning of the jurors, you need it to happen in the presence of the attorneys. You don't have a clerk do it. It's something that the judge does, and the attorneys are present. So that's a huge problem. Like Rich says, there's that appearance of impropriety. If you're a lawyer, if you're anyone involved in the case, you're not even supposed to say hi to the jurors or the potential jurors. You're not supposed to have any communication. So obviously, they're being misled. Part of the motion and the alleged affidavit, that's the most serious. I mean, that's a huge problem because, look, on appeal, you really can't get into the minds of the jurors. You know, if they consider things that, you know, maybe weren't correct or they don't understand the law. But one thing that's the basis for a mistrial and a new trial is outside influences in that jury deliberation room. And not only here you have outside influence, we're not talking about Googling or watching court TV. We're talking about a member of the court staff, if that's true, this is an absolute basis for a completely new trial.
Yeah, and it was interesting to me, they even raised the fact that according to one juror, they weren't allowed to take smoke breaks until they did come up with a verdict. And, you even question if that was an outside undue influence forcing their hand to make a decision before they were ready. I don't know, but their court has a lot to consider. Next steps, Rich, what do you expect to happen next now that this motion's been filed?
Well, there's got to be some kind of investigation. And I found it interesting. I think it was smart by the defense team to say, SLED shouldn't be doing this investigation because they were involved in the case previously. And in fact, some of their work came under examination as the case went on. So there's an initial question of who's going to look at this, who's going to interview the jurors, who's going to interview the law clerk. How is that going to proceed? They have to get the right law enforcement involved so that the facts can be vetted. And then there's a question as to what judge would consider this, because Judge Newman's been out, he's been speaking publicly on the case. He might not be in a position to take up the issue again. So we kind of have to, first things first, get in line. How is the investigation going to be done, and how is the matter going to be reviewed?
And there was a letter that was sent along with this motion, and one of the things that Dick Harpootlian said was, yes, we want the FBI to investigate, regardless of what that outcome brings. Let them investigate with a clear mind, and whatever it shows, it shows. I, too, think that's a smart request by the defense. All right, Neama, your last thoughts. What are you going to be looking for as we move forward with this Murdaugh new filing?
Well, there's no question there has to be an investigation, and I agree with Rich. It's really a question of what law enforcement agency conducts it. But I'm really interested in that evidentiary hearing. The jurors, the potential juror who was dismissed, and is Hill going to testify, or is it going to be a situation where she might have to be granted immunity? We saw a little bit of this in the Scott Peterson case, right? Because if she engaged in witness tampering, she herself may be subject to criminal charges. So what's going to happen with her? She's already come out and denied these, but is she going to actually come and testify and subject herself to criminal charges? So there's a lot of moving pieces here. But if I'm representing her, I'd advise her not to say anything and get some sort of grant of immunity before she does.
And I would think that she's hired an attorney, because I agree with you. When I read this motion, it's very lengthy with a lot of specifics in it, a few of which we've brought to you. I thought she is at risk of potential criminal charges. If any of these allegations are true, I think she is in some hot water. So we're going to see how this plays out. Stay with us, gentlemen. Still ahead.